Good afternoon, and thank you so much for joining the 19th Represents Annual Summit. My name is Grace Panetta. I'm a politics reporter here at the 19th, and I'm honored to be hosting today's Tech One-on-One conversation with Commissioner Rebecca Slaughter of the Federal Trade Commission, the agency charged with ensuring privacy, consumer protection, and enforcing the nation's antitrust laws. Thank you so much for joining us, Commissioner.
Thank you so much for having me. It's such a delight to be here.
We're delighted to have you too. So to begin, the FTC touches a lot of areas of American life as consumers, as users of the internet that we may not think about all the time. How would you kind of describe what the FTC does in your role as a regulator and public servant?
Sure. So the FTC has an incredibly important mission that affects almost every American's day-to-day life, really every American's day-to-day life. And very few people always know about it on a day-to-day basis. But we have two main missions, protecting consumers and promoting competition. That means we enforce the nation's antitrust laws, and we also enforce the FTC Act's prohibition on unfair and deceptive acts and practices and unfair methods of competition. Mostly, this means we work hard every day to try to keep people safe from unfair business practices that inhibit their privacy, their economic mobility, and their ability to participate fully in society.
Yeah, super interesting. Thank you for that primer. And I want to start with digital privacy, which is a big topic we're discussing today and a big topic of discussion nationally, and especially as it relates to health data and for women. Women make up the majority of health decisions for their families and are most often in this space. I know the FTC has recently entered into settlements with health startups GoodRx and BetterHelp. I wonder if you could speak a little bit to what you're seeing and doing in the health privacy space as it relates to data the internet.
Sure, this is an incredibly important issue for all Americans, but as you know, especially for women, and especially after the overturning of Roe v. Wade, where reproductive health care is an extremely sensitive topic and really at risk in a lot of areas in the United States. So health data has long been understood to be among the most sensitive types of data about people. It's not just reproductive health care. It's, are you getting mental health treatment? Are you getting substance abuse counseling? Are you going to a cancer treatment center? These are things that are deeply personal, deeply private, and incredibly important to people. So exactly as you reflect, we've been working really hard in this area to make sure that people's sensitive health data is treated with the sensitivity and protections that the law requires. So a couple of things that we have done in this space. We sued Kachava, a data broker, alleging that they made it possible to track the precise geolocation of people based on their mobile devices. And these locations could include places of worship or addiction treatment facilities or healthcare facilities, including reproductive healthcare facilities. That, for the record, was a bipartisan complaint because across the board, people have, and regulators, members of Congress have concerns about the sensitivity of people's personal location data. So that's one thing. We're looking at data tracking. Another thing you mentioned, we've sued a couple companies effectively for collecting sensitive health data, telling people that they were going to keep it private and then selling it for advertising purposes. This is something that we are concerned about across the board, the collection of data for one purpose and the use of it for another purpose, but it's particularly sensitive when it comes to health data.
Yeah, that's really interesting. And, you touched on reproductive rights specifically. I wanted to drill down on that because I remember in the chaotic days and weeks after the Supreme Court overturned Roe v. Wade, there being a lot of concern and a lot of articles about, should you use a cycle tracking app? Should you be searching for things on Google? How have you seen the landscape around that specifically evolve since the Dobbs decision? And what would you tell women right now who are concerned about their digital activity and whether or not it could, implicate them in a state where abortion is banned, for example?
Well, I think across the board, people need to be very careful and sensitive about their own digital hygiene. We have lots of guidance on the FTC website about steps people can take to keep themselves safe. And, in my own life, I try hard to read privacy policies carefully, follow follow what companies are promising that they're going to do with their data, figure out what that actually means, and make informed choices. But I think it is really, really important that the burden not be entirely on individual people to manage the entire black box ecosystem of data. That's one of the things we're looking at very closely. I think that the notice and consent model under which data has historically been treated is pretty universally understood to be broken. Notice and consent makes a lot of sense if you have meaningful notice and an actual opportunity to decide. In today's data economy, we don't have either of those for the most part. The way I think about it is I am a lawyer. I am extremely well educated. I have some professional expertise in the field of privacy, and I cannot understand what privacies or policies are telling me most of the time. And if I can't understand it, and I am the best suited user to be able to understand it, most people don't have a prayer. And even if I could understand it, most times, many apps sort of give you a binary choice: consent to collection and use the app, or don't consent and don't use it, or consent to collection and use my website, or don't consent and don't use it. And that's not meaningful choice. So I think we need to be really mindful that this framework that seems admirable actually is not fit for today's economy and today's technological landscape.
That's really interesting. So you're basically, you read the fine print, but a lot of the times it might not even make all that much sense.
Yeah, I mean, I think what I'm saying is it's great to do what you can to take care of your own data hygiene and be sensitive to the ways information about you is being collected and used. And I want everybody to do that. But from an enforcement perspective, we're also thinking very, very hard about making sure that companies are held to the higher standard that the law requires of not tricking people into how they give up their data and not using it for unfair purposes, even if they consent to it. I will put in a plug at this point. I just finished Danielle Citron's excellent book, The Fight for Privacy, and I know you're going to hear from her a little bit later, but she has an excellent guide at the end of that to the ways people can take more agency over their data. And at the same time, talks about a lot of the problems with the entire burden being on individuals to make those choices.
Yeah, that is really fascinating. And that'll be a great conversation with her later. Another area of digital privacy that a lot of people are thinking about right now is privacy and collection as it relates to children and kids on the internet. Gen Z, the first generation to grow up online, Gen Alpha, even more so. It's something we've seen a lot of policy making on at the state and federal level. And I'm curious to kind of get your thoughts on some of the efforts by lawmakers to address this so far. What do you think of the way that states have gone about it? And by the way, some federal lawmakers and Congress have tried to introduce bills, for example, limiting what age kids can go on the internet, trying to enforce things like age verification, and even trying to ban social media companies from using algorithms to show kids under 18 content. Is that an effective way of addressing those concerns?
Yeah, there's a lot to unpack there. Let me start with the general concept of kids. The law has, for several decades now, reflected that kids are particularly sensitive population and their data needs to be treated with sensitivity. The big federal privacy law that the US has at this point, until we get a comprehensive national privacy law, which I really hope we do, is the Children's Online Privacy Protection Act. And that was a groundbreaking law at the time it was introduced and has provided some really important changes, but it also relies primarily, although not exclusively, on the notice and consent model. It's a put parents in the driver's seat idea. And as a parent, I think about this the same way I do thinking about myself as a user. I have 4 little kids. And as I mentioned, I am a something of a privacy expert, very well educated. I'm also a pretty hands-on parent. I'm really engaged with my children. I cannot be in the driver's seat of all of their interactions with technology. And this was true before the pandemic, and they went into Zoom school. And even now, as they've come out and they're back in-person school, but using different kinds of tech platforms all day, every day. Even if I didn't have a job, really, even if I only had one kid, it would be a full-time job to manage that kid's interactions with technology, and it's just not possible. And I think lawmakers have recognized this, and there are proposals to update COPPA. As you reflected, there have also been a lot of movements in the states about kid-specific legislation. I will tell you, I think, just my personal opinion, is that among the more promising of those are the sort of design code models that require companies to think about the interests of a child when they are doing design. I worry a little bit right now about models that rely on age verification, because I think there is, at least so far in how the technology has developed, a real tension between the desire to age gate something in order to protect children's privacy and the necessity to collect a lot of really personal information about people in order to do that age gating. So I think that's a real challenge. And so I have some skepticism about that area. I also think kids are not monolithic. You know, my 8-year-old is much more online, you know, like of that universe than my 10-year-old, who is really much happier playing basketball. So, you know, kids are different. And I think we have to be sensitive to that. But I'm encouraged by all the attention that's being paid in legislatures across the country and in Congress to the issue of kids specifically. And it's something we're focusing on at the FTC too.
Yeah, and how do you think the tech platforms are doing on this front? Because it seems like almost all the advertising I see from Meta and from TikTok is, you know, touting all these tools they have for families and how they're trying to keep kids safe, which I think is very telling that they're expending a lot of resources marketing on that. But how are they doing in practice?
I'm glad it's something that they want to market on. I think that the data about kids' interactions with tech platforms on everything from privacy and safety to the really very serious mental health concerns, especially for teens, suggests there's a lot of work left to do. I have huge anxiety about this as a parent and as a law enforcer. I think that there is a lot of room for improvement. And I think that the more evidence that comes out, the more concerned we should be.
Yeah, it's going to be a really interesting arena to watch going forward. I want to move now to some other consumer protection related topics. It was really interesting. I was listening to an interview that the FTC's chair, Lena Khan, did on NPR's Marketplace recently, where she mentioned some of the shortages of things like formula that a lot of women and families have been experiencing over the past year. And that was not something I initially connected to the FTC. So I was really interested to hear her talk about that. And I'm curious if you can speak a little bit to how your work on competition, antitrust issues affect some of these everyday shortages of goods that consumers have been experiencing.
Yeah, I think this is such an important point. So it's a question of both shortages. I think it's a question of access in terms of both shortages and prices. One of the things that is true across the board is that when markets are more concentrated, the market players can raise prices, which can inhibit access, especially for lower income people. And when it's a necessary good, like formula or groceries or healthcare, that's critically important. Another area is when we look at supply chain shocks in a concentrated market. If there is only one or two players and something goes wrong at one of them, then there is no backfill into that market. And so you see things like we saw with the formula shortage, which is life-threatening for babies, devastating and terrifying for their families. So having competitively healthy, vibrant markets is not just about esoteric antitrust terms like hypothetical monopolist tests. It's about the day-to-day experience and opportunity of people to participate in the economy, make meaningful choices, and access goods and services that are innovative, competitively priced, and available.
Yeah, it's really, really interesting. And another area sort of related to this, but more about the labor market, is we've seen a lot of recent waves of layoffs across multiple industries, some higher profile things that have happened in the media industry that have highlighted the ubiquity of non-compete agreements, which I know the FTC is trying to prohibit. How do non-competes affect the labor market, and specifically women workers and workers of color who may be already at a disadvantage?
This is a great one. And this is another one of those areas where at the beginning I referenced the fact that our work can touch everybody's day-to-day lives, but in ways they may not know is happening in the background. Non-competes, by their very definition, raise questions from a competition standpoint. They are a requirement not to compete. In competition law, we usually want people competing. What it specifically refers to is a restriction employers put into employment contracts that say workers cannot leave their job and go work for someone in the same field in within a certain geographic radius or for a certain amount of time. In practice, this can mean that if you are stuck in a job that is not treating you well, either not paying you what you deserve, which we know happens to women all the time, where workplaces might be abusive, which unfortunately we also know happens to women all the time, people can be trapped in those jobs and not able to go seek other employment. And that is really devastating. It's economically devastating. It's also psychologically devastating and emotionally devastating. And the data that is in the FTC's notice of proposed rulemaking on this topic reflects that this happens not just to high-level executives, and honestly, not just to lower-level hourly wage workers, but to everyone in between, from hairdressers to, my kid's karate studio teacher was bound by a non-compete that required him to stop working for a couple of years after he left the current studio. It's across the board, and that is something that is really concerning. So we have, as you suggested, proposed a rule. We will study the record very carefully and with an open mind and figure out whether it supports finalizing a rule or making any modifications to a final rule. But I think the question of non-competes is a really important one for people to be aware of. And I'm hopeful that the public dialogue that has started about it in the wake of our proposal will also help more companies attract talent by saying, we won't bind you with a non-compete. We will pay you what you deserve. We will give you the benefits that you need. And that's how we will attract better and better talent.
Yeah, I think it's a really, really interesting arena. And what are kind of some other ways that the FTC is thinking about some of these labor fairness and worker protection issues as it relates to boosting competition and antitrust even?
So antitrust law has always been able to take account of labor issues. We talk a lot about monopoly, and most people know that the term monopoly means you have a single seller who can control the price and raise it really high. There's a parallel term, monopsony, and that means you have a single buyer who can depress input prices and control the input market. Those sound like fancy antitrust terms, but if you think about it like this, if there's only one employer in your town, that employer has an enormous amount of power over who they hire, how much they pay, and there isn't fair competition for labor, which tends to be an input into markets. So we have looked at input markets on other sort of materials that go into competition, whether it's the price of supplies, but labor is one of those things. So we are looking at input markets, including labor, in a lot of our merger investigations these days. And we had a hospital merger challenge last year where Chair Khan and I wrote that we would have included the merger on a labor basis. We also are looking at labor from the perspective of the gig worker economy, or the fissured workplace. And this, I think, is an area that's especially important for women too, because women often need more flexible hours to accommodate childcare or other caregiving responsibilities. And that's great. We want people to have flexibility in the workplace, but flexibility does not mean exploitation. And we need to ensure that companies are treating all of their employees fairly, whether they are fissured employees or traditional employees. And so we had one case where we challenged Amazon Flex for lying to its drivers, who were gig workers, about how much money they would get in tips, basically for withholding the tips of the promised tips of its drivers, and we were able to return money to drivers for that. And we did another policy statement on gig workers that talked about the ways in which we're going to try to make sure that they are treated fairly in the workplace, even if they are not classified by their employers as traditional employees.
Yeah, that's really fascinating. I think that connection between these big concepts that might seem kind of inaccessible in everyday labor markets is so important. One thing we haven't talked about yet that is a big thing in the tech world right now is AI, artificial intelligence. We could probably spend a whole day of this summit talking about it. But I'm just curious to kind of get your thoughts on the intersection of AI and some of the privacy and consumer protection issues we've been talking about. What are kind of the opportunities and challenges that you see as a regulator in this very fast evolving space?
Yeah, you're right, could be the topic of a very long conversation, but I will try to distill it down to a few key points. I wrote a law review article a couple years ago about this, about algorithmic decision-making and economic justice. And I think the point that I made there, that my colleague Commissioner Bedoya has made recently, that Chair Khan has made recently, is that these are new technological tools, but the rules still apply to them. And we look at them through the lens of the FTC Act, the same way we look at other conduct. And so the things that jump out at me as particular sources of concern are misrepresentations about what tech can do. You know, a promise that your AI can solve all the problems or discern somebody's personality from a picture. And those are marketing claims that we would investigate and challenge the same way we challenge other marketing claims about what your health supplement could do if it's not backed up by reliable scientific evidence. So that's one area. I think an even bigger area of concern is the way AI can perpetuate and exacerbate disparate outcomes for people. So, you know, everybody, I think at this point knows the example of the hiring algorithm that was trained on a dominantly male, on a company's current pool of employees, which was predominantly male, and went on to suggest only male candidates because it was replicating the discrimination that was baked into the data set. And women, I think in particular, can be made invisible in input data sets, and that problem can be duplicated, exacerbated in the output set. And I think this is where intersectionality becomes particularly important, because women are made invisible, people of color are made invisible, women of color sort of get the double burden there. And I think we can't lose sight of those really troubling lenses that are applied. And then I also think we have to think really seriously about the role of AI and competition and the ways in which broad data inputs can exacerbate some of the anti-competitive dynamics in tech markets already. So those are three buckets, probably not the entirety of the universe, but just some of the things we'll look at. It may be that these tools require new specific laws and rules. And I am very, very open to all of the different legislative efforts to address them. But in the meantime, you know, the way I think about our job is we have to do the best we can with the laws we have right now, you know, even if we think it would be better to have different laws. So we are trying to use the entirety of our toolbox. And one thing that we have not mentioned so far today, last summer, we opened an advance notice of proposed rulemaking on data security and commercial surveillance. And that record asked a lot of questions about some of these issues that we're talking about today, including AI. And so we are currently reviewing that record and hope to come to next steps sometime this year so that we can move forward, if the record supports it, proposing any specific rules that might address some of these issues.
That is all really, really fascinating. And that segues into the last topic I want to touch on today, which is your relationship with the Hill, the policymaking process. Right now, Congress is divided, but there are a lot of members of Congress on both sides of the aisle who feel very strongly about all of these topics we've been talking about, whether it's tech regulation, privacy, competition. How are you, navigating things with the Hill? And do you expect any major bipartisan tech or antitrust policy bills to come out of Congress in the near future?
So I worked in Congress for a decade before I came to the FTC. And what I learned there is should never bet money on expecting Congress to do or not do any particular thing. So I try to be out of the prediction game. But what I do know is that the necessary ingredients for moving forward on some of these important issues are there. There's bipartisan concern about the power of tech platforms. There's bipartisan concern about the mental health challenges kids and teens are facing in the online world these days. There's bipartisan concern about the market power of large companies across the board. And so these are all avenues where I think there is the sort of necessary ingredients to get to some kind of compromise. Congress, on a bipartisan basis, did one of the most important things for us last year, which is not glamorous from a legislative perspective, but they gave us a little bit more money. And that makes a huge difference. The FTC has been systematically underfunded for decades. And in fact, we currently have, at the beginning of the Reagan administration, we had about 50% more employees than we do today. So if you think about the scope of the questions that we have to grapple with, the way the economy has changed since 1981, and the fact that we're doing it with 2/3 the number of people that we had then, that is a real challenge. So the funding boost, again, which was passed in the bipartisan omnibus appropriations bill, made a huge, huge difference. And hopefully Congress will continue to build on that down payment and help us have the appropriate tools to tackle the very real and rapidly changing problems in today's economy.
Yeah, and just quickly, what are you also seeing in the states? Are there any interesting state level policies you think have been particularly impactful, ones that maybe Congress could go off of?
Tons. Well, California has been a huge leader in the privacy space and the tech policy space, and I think that work has been enormously important. And California is not the only state that's grappling with these issues. I think there are 6 different states that have now passed data privacy laws. That is great and important innovation in the absence of congressional action. Illinois has a biometric data law that I think is really important when it comes to people's most sensitive personal data. And I think, you get to see some of the benefits of the laboratories of democracies that work in this space. That said, I worry about a universe where Californians have protections that Minnesotans don't. And from a federal perspective, I would really love to see a federal floor for some of these protections. If states are doing something effective, let's build off of it. I also think we can take important lessons from our colleagues overseas in the UK and in Europe. They are grappling with digital market power and digital privacy issues directly and aggressively. Some of the laws that they pass, I think, have real value. Some of them are ones where we can learn lessons about what works well and what doesn't. GDPR, I think, has really important provisions and protections for how data is handled. I also think we all hate the cookie pop-ups that started appearing after GDPR went into effect. And to me, that's a great example of a well-intentioned provision that doesn't work as it was intended. I don't think it's giving people real meaningful choice about cookie acceptance, and it is creating just sort of like extra friction. And that's okay. That's always what happens when we work on new policy. And so our job is to iterate, is to look at what works and to build on that. And that's what I think about the FTC's work generally. The agency has an incredible tradition of self-critical examination. We look at what we've been doing and we try to improve and we try to learn from it. And we're at a moment where we have a real opportunity to learn from and build and grow from the last couple decades of how we've approached enforcement And what we're trying to do right now is really dig into our toolbox, make sure we're using all of our tools as effectively as possible and reaching all Americans in our enforcement efforts, and not letting any group be left out or left behind from the protections of the law.
Yeah, that is so, so fascinating. And that is unfortunately all the time we have for today. Thank you so much for joining us, Commissioner Slaughter. This has just been fascinating.
Thank you so much, Grace. I really enjoyed our conversation.
I'm now thrilled to hand things off to Natasha Tiku. Thanks so much.